Of all the crime reported in India, just 1.2% is committed by juveniles. The new Juvenile Justice Bill passed by the Lok Sabha allows for 16 to 18-year-olds to be tried as adults in cases of heinous crimes. Of the 40 new amendments in the bill, this one is the most controversial. This move was prompted by the rape and murder of Jyoti Singh in December 2012 because a 17-year-old along with 5 others was convicted for this crime. Experts say this move will appease public opinion, but for kids it's a gross injustice.
Emotional blinding takes place when the prefrontal cortex sleeps and the entire response is by the amygdaloid. That has been seen when man was living in the caves and he had to save himself from danger. Slowly as man evolved, we started using a prefrontal cortex where between an urge and action is a thought, and the thought helps us to discern whether this act is socially appropriate or not. Between the ages of 12 to 18, the chances of emotional blinding is very high. The chance of emotional hijacking is very high, where the prefrontal cortex sleeps and the child might attack, the child might impulsively act.
Under law, you have to have a particular cut-off date. If you make it 16, there may be a particular child who is 15 years and 8 months who is going to do something which society believes is heinous. So in the law, you have to have a cut-off date. Okay, and beyond that, there will be different treatment. Under that, there will be different treatment. You cannot keep a variant age.
Besides ignoring scientific rationale, the new provision fails to take into account the fact that the juvenile justice system is overburdened and inefficient. Juvenile justice boards that will now have the power to decide whether to try juvenile as an adult or not will have to be reconstituted to include psychologists.
There is an observation home that is required where children are, there is a place where they need to be kept. There is a special home that is required. There is a whole, there's a need of counselors. There's a need for mental health officers. There is need for a police, probation officers. All these are support systems which have to work together for the rehabilitation of these children. But unfortunately, over a period of time, that's not how it's panning out. There are many systems that are just not in place. For example, the whole system of probation, it's dying over a period of time. The role of probation officers are now being taken over by lawyers. So the whole idea of the JJ system was it is supposed to be a socio-legal legislation. In the sense that you cannot deal with any child, be it a CNCP or a JCL, only from a legal perspective or only from a social perspective. There needs to be a combination of a socio-legal understanding when you are dealing with a child. And with the probation officer's role that is slowly deteriorating or almost like it's kind of moving out, the lawyers have stepped in and there is a lot of legal intervention that is happening in place.
You have the Juvenile Justice Board, which includes of a principal magistrate and 2 social workers. You have to identify the most suitable person to sit on that chair. It's not that we don't have the human resources, we have them, but to identify and select the correct persons. And everybody has been talking about that, but still in the new act, or the bill, sorry, in the new bill, nowhere have you mentioned about a selection committee which will ensure that the correct human resources are identified. Because what we see is, today it's very individual centric. If we have a very good juvenile justice board, if we have a good superintendent in the homes, the children are flourishing. Okay? So it's identifying the right one so that the child is suitably and comprehensively rehabilitated.
1.7 million children are caught in the juvenile justice system, and this number is bound to be higher because this data is from 2013. The government says the new amendment will reduce crimes against women, but experts dismiss this effort because the actual number of crimes committed against women by juveniles is a minuscule one. They say if you really want to combat crime against women, then you should focus on the adult men.
We are also looking at what is heinous, because the Act says in case of heinous offence, the JJB will take the discretion. It will be left to the discretion of the JJB to decide whether the case will be heard here or in the adult court. What is a heinous offence? is very subjective in many terms. If you are looking at rape, our working experience shows that 99% of the cases that come are elopement cases or affairs, and it's always the girl's parents who file a case against the boys, and unfortunately the girl cannot say that, listen, I like this guy and I ran away with him out of my own accord. So the boy becomes a rapist and the girl becomes a child in need of care and protection. So our social system is such that we'll never acknowledge that even a girl can take a boy and run away. So there are such changing realities which are not being able to get captured out here.
By the way, experts say this bill violates Article 14 and 15 of the Indian Constitution, and if it becomes law, it has international ramifications. India signed the UN Convention on the Rights of a Child in 1992, and if this becomes law, it would be globally condemned and can also be challenged in the International Court of Justice.
Convention on the Rights of the Child hasn't just come out with a magic age. There is science behind it, there is sociology behind it, there is psychology behind it, and that's why you come to this age of 18.
There are some sections in the civil society that are lobbying hard to stop this bill from being passed in the Lok Sabha. And they say there are other provisions that are also a cause for concern, like the changes made in the adoption procedure. But that will have to be another report.